Good evening from India, and this is Abhivardhan from Global Law Assembly and the Indian Society of Artificial Intelligence and Law. So here we are with the seventh episode of the second season of AI Now with Dr. Roger Brownsford from King's College London. We are very delighted to discuss his just recently published book in the year 2020, Law 3.0, Rules, Regulation and Technology, which was published by Routledge on July 22nd, 2020. Now, I'd like to introduce the speaker so that we proceed with an interesting discussion of his book. So, Professor Brownsford, who is a graduate of the London School of Economics, he has been an academic lawyer for 50 years. First, and first he has been at the University of Sheffield, and then he has been in the King's College London, where he also was the founding director of TLEOS in 2007. He was a Leverhulme Research Fellow in 2003 to 4. He's a member of the law panel for the UK RAE 2008 and then for the Hong Kong RAE 2014. He has published about 20 books, most recently Law, Technology and Society, Reimagining the Regulatory Environment, and more than 250 chapters in books and articles. And of course, since we are discussing about Law 3.0, we will be discussing the basic issues and also the procedural aspects of administrative law and how they intersect with the development of emerging technologies. So, sir, welcome to AI Now, and we are grateful to have you.
Thanks very much indeed. Yeah, hello from the UK. It's early afternoon here. But it's good to be able to talk. You want to open up with some questions on the book, or do you want me to say a few words about the general idea of Law 3.0?
So, I would appreciate if you would like to shed some light on the book, give some general idea on the same, and then I'll ask you some questions.
Sure. Okay. So the Law 3.0 is trying to capture the way that we lawyers engage with technologies which are now of interest to us, because I mean historically technology was not something that was any particular interest to lawyers any more than I think law was of interest to technologists. A conversation between a lawyer and a technologist, at least when I was a law student, would have been pretty short. You know, lawyers wanted to talk about law and technologists wanted to talk about technology. So but I'd say from the 1990s onwards, particularly the modern biotech and developments of the internet and information technology, it's become clear that lawyers need to take an interest in what's going on in the world of technology, and not just IP lawyers, who always, of course, are interested in innovation, but lawyers generally have to think about what's going on in biotech and information technology. And since then, there's been a whole raft of new technologies, leading particularly now to an interest in AI, machine learning, and robotics, which I think are energizing the interest of lawyers. But the question is, how do we lawyers engage with these technologies when we're asked to think about them? You know, what's our modus operandi? And Law 3.0 is trying to capture three different kind of conversations, or three modes of engagement that you'll find as lawyers encounter these technologies. It's not just three conversations, but three conversations which coexist. Law 3.0 is one of the conversations, but in kind of capital letters, it's the whole universe of legal conversations where there's a Law 1.0, a Law 2.0, and a Law 3.0 conversation that's distinctive. So briefly, Law 1.0 is the traditional way that we lawyers respond to any question about a novel situation where someone said, well, what's the legal position here? You know, what we're trying to do is usually return to the general principles, which are the cornerstones of contract and torts and criminal law, property law. You know, the cornerstone principles on which the law has been built, at least, well, at both the civilian world and the common law world. We're asking ourselves, how are these principles now going to be applied to these novel technologies? So, for example, with artificial intelligence, devices are enabled by artificial intelligence, including, say, autonomous vehicles. You ask a lawyer, well, how do you think these new modes of transport will fit with the traditional principles of law? And probably the first questions will be about tort law and how how tort principles about negligence liability or product liability possibly will play if there's an accident involving one of these vehicles, that kind of thing. So it's a question of, we've already got a stock of principles, and we're now going to try and apply these principles to these new phenomena, even though the world in which these principles were devised or articulated was very different. I mean, it's there's a lot of interest from private lawyers, especially in trying to tell people who are doubtful about this, that the common law principles do have a capacity for adjustment, for flexibility, and application to new phenomena. We shouldn't underestimate just how much resource there is there in our traditional principles. A famous article at the end of the 19th century, Warren and Brandeis, when they talked about privacy, didn't argue that we needed new legislation to deal with privacy. They said, we can develop tort law in a way that will handle this. So that's the first response. That's Law 1.0. It's a conversation we're all very familiar with. And in law schools, I know some of the questions you have are questions about legal education. In law schools, this is the way we teach people to think like lawyers. What's involved in thinking like a lawyer is understanding these principles and being able to apply them in an imaginative way. Now, Law 2.0, the second conversation, is very different, because it sort of pretty skeptical about about the capacity of these historic principles, flexible though they might be, to actually engage in a satisfactory way with these modern technologies. And in Law 2.0, which you can see beginning even in the middle years of the 19th century, when modern transportation systems like railways were creating questions about the applicability of historic laws, you can see that there's a new mindset, a new conversation, where the focal question is about whether the law is fit for the purpose. I mean, that phrase, is it fit for the purpose? A phrase we hear all the time these days. But once upon a time, I don't think during my undergraduate career at the London School of Economics, anyone has said, well, is the law fit for purpose? I just didn't hear. That wasn't a question you heard. But once regulatory people come on the scene, and this is a regulatory conversation we're talking about in Law 2.0, that is the question. And it's often put in terms of, are the rules fit for purpose? Or is the regulatory environment fit for purpose? And the purposes we're talking about are the sort of general purposes about innovation or health or whatever it might be, economic purposes, social purposes that are fixed by the regulators. So there are policies. So one of the big distinctions here is that the Law 2.0 conversation is typically driven by regulatory policy. It's orientated towards serving those policies. Whereas the historic Law 1.0 conversation tends to be more about the principles. And people think there's a big difference between principles and policies, and who should be, formulating policy within the polity. And that's the difference between, a big difference between Law 1 and Law 2. So in the book, I start off with a conversation that we had a couple of years ago when London Gatwick Airport was closed down for a couple of days because an unauthorized drone was sighted at the airfield. And in the aftermath of that, one of the things that people were saying, particularly pilots, was that they've been telling government for some time that the rules about drones and the exclusion areas around airports, that they were not fit for purpose, that the exclusion areas needed to be bigger, more extensive. You had to keep drones well away from aircraft because they were very dangerous, even though they were small. They could cause a heap of trouble. So that was classically kind of Law 2.0 thinking. And no one there was talking about how historic principles of tort law might be used to deliver compensation should people get injured. That really was, it was a more regulatory conversation. Then Law 3.0, it has a lot of similarities to Law 2.0 in the sense that it's about regulatory purposes and how best to achieve them. But here the big difference is that for the first time in a systematic way, we start thinking about ways of achieving these purposes without using rules, not relying on rules as such, or principles or standards, not norms. We're not relying on a world in which we have a code that says this is what you ought to do. That might be part of the picture. And we need to get that as fit for purpose as possible. But these instruments or these tools, which we're worried about regulating, in the sense that they're out there being applied and we need to have legal and regulatory frameworks, we now apprehend that these are tools which we lawyers and regulators can use for our own particular purposes. It's not other people who are going to be using AI or whatever it might be. These are tools which we can use too. And so, again, going back to the Gatwick example, many people were saying after that drone incident that the ideal way of dealing with this would be to find a technical fix. That it would be far better if drones could be designed in a way that ensured that they respected, if you like, the exclusion zones, the rules put around airports. And in the same way, I mean, just think about autonomous vehicles. Well, we've got all sorts of road traffic laws, all sorts of rules, and we want our autonomous vehicles to observe these rules. But the way in which they're going to be observed in fully autonomous vehicles is not through a human driver who is, or even a remote controller who's trying to follow the rules. The way they're going to be observed is because the design of the vehicle will embed these regulatory devices in ways that will ensure that they are safe. And indeed, I mean, it could be that a technically controlled vehicle comes to set the safety standard for human controlled vehicles in due course. But so Law 3.0 is a conversation where it's what's distinctive about it is not so much that it's regulatory. I mean, that makes it different from Law 1.0, but that we're now thinking that not just about rules, but non-rule solutions to our regulatory challenges. And we're bringing technology inside law. It's not out there, something that we have, a target for regulators. It's a tool that we can use. So those are the three particular conversations. I mean, there's a lot more I could say about each of those, but just to return to the point I made at the start, which is that I don't want, although there's a sense in which Law 1 is where we start, and Law 2 kind of comes in to partially replace it, and then Law 3 comes along. These, at the current stage, these three conversations are still all in play. And again, to go back to where I started, I'd say private lawyers in particular are very interested these days in telling us just how much capacity private law principles actually do have to deal with some of these problems. So if I can mention another book, which is you might know, but recently published by Simon Chesterman, who is published by Cambridge University Press, only published last month. Simon is the Dean of the Law School in Singapore, National University of Singapore. He has a book, first part of which is entitled We Robots. And I mean, excellent book, but a lot of what he wants to say in that book is that we don't need to look for completely new solutions to the challenges we face with AI. That a lot of our concerns here can be taken care of fairly easily by traditional principles, or by to some extent by regulatory resources that we already have. So it's neither. As I say, people are saying you don't underestimate private. On the other hand, of course, you should not overestimate what it can do. So that's a kind of sketch of what's going on in the book, and the image on the front cover of the book of three sort of spheres which are in orbit is trying to capture the idea that there are these three conversations. That's the sense of it.
Indeed, when you mentioned about the role of private law and of course the role of self-regulation and the very emanation, I think as we proceed with the questions, we will get more clarity, maybe based on the examples you have cited in the book, and of course, as you have explained the phenomenon itself. So, my very first question to you is that when we go through your book, we find that there's a wonderful segmentation of the descriptions, particularly. Now, you have given the segmentations, the description of the segmentations already. So I'll not get on the direct question whether you should describe them again. But yes, of course, as you mentioned about the role of private law, do you think that in the domain of disruptive technologies, in the way legal approaches are to be developed, soft law is playing a role? Because somewhere down the line, even when it comes to self-regulation and other phenomena, soft law is something which is not necessarily your hard law component. It is not something top-down, which is under imposition, which is like, as you said, You don't need something to codify at the end of the day. What you need is particularly regularizing them and keeping them under the same shape so that they go ahead. I'm just simplifying it for the viewers also, who are not very much skilled in the field of law, but of
Hmm.
course for also those who are already skilled in the field of law. So, if we consider that perspective, what is your take on the development of the field of soft law when it comes to disruptive technologies, especially AI, in which our organization works?
Yeah. Okay. Well, thanks for that question. So I think the distinction between hard law and soft law is one that we tend to find crystallizing in Law 2.0 conversations. I don't see too much. I mean, in Law 1.0, the idea is, I remember Carl Llewellyn, the great common lawyer, told his students to put their ethics into a state of temporary anesthesia. He said, because we're trying to isolate the positive law, and insofar as ethics is some kind of soft law supplement. Yeah, it's okay. It's internalized by a lot of law. You look in contract law. A lot of contract law is, as it were, soft law and ethically sensitive too. Because for example, a general principle that you should negotiate and transact and perform in good faith. Or the good faith doctrine is how do you put some content into that without being ethical? And so there's a sort of a soft there is a kind of soft belly within the hard law of law one, but I don't think that in that conversation there's such a sharp attention to hard law and soft law. Now in law 2.0, though, that becomes a very pertinent issue, because one of the first lessons as we try in a law 2.0 kind of way to regulate these new technologies is that, particularly where we're looking at putting our regulatory framework into a hard legislative form, we can congratulate ourselves. We can often congratulate ourselves on the day of enactment of the legislation, say, "Well, that's quite," but a few days later, we'll probably be regretting that we drafted the legislation in a particular way we did and can't now adjust it, because we realise that the technology has either now developed in a way that we didn't quite anticipate, or that people are beginning to apply it and use it in ways that we didn't anticipate. And that what you need is some sort of flexibility to be written into these hardwired legislative forms. And so that immediately points us in the direction of soft law of one kind and of another. And so, in Europe, the literature on soft law, which goes under at least a dozen different names, of experimental governance, reflexive law, responsive law, they're all kind of more agile, flexible forms of law. Now, I'm not sure whether it was just that softness and flexibility that you were interested in, because a lot of people would say with AI that, yeah, we don't really know quite what we are dealing with yet. Maybe we do need some fairly hardwired stuff early on to protect against our worst fears, but otherwise, we have to. We're learning, and in the way that new technologies are put into sort of regulatory sandboxes to try and learn more about the technology and have the regulation evolve with, as we understand more about the technology and its interaction with people in humans in particular situations. You could say, well, that's the kind of model we're looking at. But at the same time, an awful lot of the soft law around AI, as you know, has been ethical in its, and people here are thinking about, the ethification of the law. So that in Europe, where now one of the main topics of conversation is the proposed, or people talk about as the AI law within the European Union, but a proposal for a regulation on AI, that was preceded by, by a so-called expert group, an ethics group of about 50 people who were then writing a kind of ethical framework or principles for the governance of AI, and that was taken up by a number of other bodies, including the OECD. And so you can sort of see that there's a soft law venture there that's there's a preface to a harder intervention, because it'll take years for this regulation to get through the process. But also, of course, you've got industry um, making its own pitch on codes and guidelines and again ethics, so that there are a number of different voices out there trying in a soft way to either, I think, prepare the ground for these new technologies in a way that, well, supposedly will be in the public interest, but you might say, well, at least where the private sector's involved, they have their own particular interests to promote, and which would be perfectly understandable, and they necessarily to give some shape to the codes that they propose. But yeah, I think in Law 2.0, we know that we need to have some flexibility to enable us to adjust to these rapidly changing situations, because the technology just doesn't stand still, and one of the big challenges obviously is to make the regulatory intervention at the right time and in the right way. And different regulators respond very differently to that. So, for example, if you look at the way regulators have responded around the world to blockchain and cryptocurrencies, in some places they were very nervous about this from day one and just wanted to put a stop to it. Other places they were really, quite keen on the idea. And yet in other places like the UK, we didn't know whether we were for it or against it. We wanted to kind of wait and see. And so, for a long time, our Financial Conduct Authority has been monitoring this. And of course, in the 5 or 6 years they've been looking at it, the scenery in relation to cryptocurrencies and all the other crypto assets has changed quite dramatically. So, there might be some sense in waiting and seeing, but it's difficult. Now, I haven't said anything there about how in Law 3.0, moving on to the third conversation, we have a kind of soft law input. But the thing that worries me about the direction of travel is that the attraction of Law 3.0 and technologies that seem to give an improved performance in regulatory functions or legal functions is that we kind of thinking. Our thinking's channeled in an instrumental way. We're thinking about what works. That, to put it very simply, the attraction is that a technical fix might work better than a rule. Like, again, with the drones, if you want to stop drones getting onto airports, a technical fix, or again with autonomous vehicles, you want to stop these cars killing people, a technical fix might be more effective, work better than a rule. Now, that doesn't mean to say that you couldn't also be thinking about whether the technical fix was legitimate, but I've just got a feeling that particularly where particularly where we come to emergency situations, but where the need is more urgent and pressing, like say with the pandemic, if you can come up with a technical fix which promises to work better than any other kind of instrument we've got, it's going to take an awful lot of persuading people that you shouldn't go with that, because it would be the wrong thing ethically to be doing. And so I think it's very important indeed that we maintain the kind of ethical critique of governance, and maintain the integrity of that critique. So soft law definitely has a role here. And well, I mean, giving this a further twist again, some people would say that just like you can, well, design some, say, safety features into a technology, you can also design ethics into the technology, so that when people talk about privacy but by design, or privacy protecting technologies, or dignity protecting technology, whatever they might be, the idea that the ethics can be converted, kind of coded in, that worries me too, because I've got a feeling that what you're going to be coding in there might be a particular kind of ethics, which is not going to be something that everybody is going to sign up for. But yeah, sorry. So that very interesting question, and sorry, this rather sprawling answer to it, but I'll leave it
Sure,
there.
definitely. I really appreciate that you gave time to this question, but it just came out of my mind, so I did ask. So my second question, which is related to your book, is that, uh, of course, the questions of ethical dilemmas and conundrums have been, discussed in this field, and you have kind of explained about, that there should be some balance around. We just can't codify everything. And as you've explained about the very development of soft law, I think one thing which comes into my mind is that if there are disruptive innovations which are coming, because I remember I had a conversation with an academic in Europe. So there was a particular workshop in which I participated, and I asked a simple question: that's if it is very much proposed that any disruptive technology can impact, and there are private actors who are trying to gain up with, like for example, there's a very interesting IP case which came up regarding an AI software, in which an Australian judge stated, which was the Taylor versus Commissioner case, which is related to a software named Dabus. So the judge stated that, okay, fine, this is a particular technology. There's a difference between an inventor and a patentee legally. This is his opinion. But he also pointed out one thing in the simple judgment, that it doesn't mean that the same judgment can be generalized for any other kind of AI based technology or particular disruptive technology per se, because the relationship itself can be, from a procedural point of view, can differ a lot. So, considering that there will be legal challenges all time emerging, can you give some brief examples as to elaborate upon, from not just the IP perspective, because you have very rightly said that IP perspective is just one component of it, maybe in the past aspect of the conversations, which is 1.2 or 3.2.2. But if we interlink this together, because creative interpretations are being made, creative approaches are being made in legal policy, uh, how should legislators overcome the problems? Of course, there cannot be a coherentist approach completely, but what else can be done forward?
Well, you covered a lot of ground in that question. I'm not sure that sorry, I don't know whether I've got the question that you really want to ask me here. Could you just have another shot at, because you did say that there was quite a spread of ideas in that, and I wasn't sure quite what the question was in the end.
Sure. So sorry for that.
No,
Actually,
it's fine.
yeah, I just put actually those points also because I found them relatable. So the simple question is that, at least we have started realizing in jurisprudence, at least in this field, that you just can't go with a hardliner approach, and you just can't block it the way that, okay, fine, you just come up with any statute or law and then get it done and block something, because again the simple problem is the penetrability, which is how maneuverable any technology could be and how penetrable any technology could be. So if these things come in the aspect of regulatory theory, how should legislators approach? So you can elaborate by giving a few examples. You gave the drone example, of course, but if you may give examples on how UK and European countries are trying to do it first, and even if the United States is trying to do so. So it's something which is an extension of what you have stated, but in a different sense, because I gave you an example of that Australian case, of course, that they
Yeah,
have said that. So
yeah. Well, again, I'm not sure that I'm giving you the answer quite that you want to hear, but yeah, I mean, first of all, I say that although I think that a law two conversation is the kind of conversation that we need to have often, and that law 1.0 conversations don't really get us, don't really engage with things in a way that is productive, as productive as it should be. I don't want to give the impression that law two is an easy ride for regulators. That law two, as I've explained in some other books, is, there are multiple challenges for regulators who are trying to deal with a world of fast moving technologies, and the I mean, one way in which regulators have more flexibility than, I think, judges, who are largely concerned with law 1.0 kind of conversations and discussions, is that they don't have to maintain coherence, doctrinal coherence, in the way that we expect in a law 1.0 conversation. Some of the questions that you put to me in advance of our meeting today, highlighted this idea of coherence. But I mean, I should have said, that teaching people to think like lawyers in the traditional law 1.0 way is binding them into this idea that across doctrine as a whole, it has to be coherent. You can't have contradictions. You can't be saying one thing here and then ignoring it over here. Well, at least that's the ideal. That the integrity of doctrine is, a good thing in itself, and we aspire to that. Well, regulators don't need to worry about that. I mean, they don't need to worry about the integrity of doctrine as such. So, for example, I mean, I know you said examples other than IP, but you've already given the example from Australia, where, I mean, in a similar way, one of the burning questions in IP is about whether the creative outputs produced by AI should be eligible for copyright protection, or indeed, I think the Australian example is about patent protection. But I mean, either way, whether it's patents or whether it's copyright that you're talking about, does the creator have to be a human person? Does the author have to be human? That would be the sort of issue. And now, the principles of IP and their legislative enactment all seem to assume that we're dealing with humans who are the creators of original work or inventors of original work. And if you're now saying no, that actually this creativity came entirely from some machine or software that produced this, how does that look? And in a law 1.0 conversation, I think there'll be huge resistance to the idea that we should be recognizing this as, and the question what we should do, I guess in law 1.0, people would say, well, look, you're just going to dismantle IP law if you recognize machines as in this way. And this is really a policy question for regulators and legislators to debate and decide. Because in the end, we want to, so it becomes a law 2.0 conversation where the question is, well, what is the purpose of IP law? What are we trying to achieve? And people say, well, we want IP laws to work for the public benefit. They need to be for the public good. And they need in one way or another to incentivize beneficial innovation or beneficial creativity, culture, cultural productions, cultural work. IP law reflects the kind of incentives and rewards that we try to put in place to encourage that to happen. That's the thinking. Now, obviously, there's huge debates about whether IP really does do what it's supposed to do. But the question then would be a question about whether recognizing AI as having IP rights would promote that public good. And if you say, yeah, but we don't recognize anybody other than a human, regulators say, well, no, I know we know that, but there's no reason why we should have to. All bets are off here. We can do what we like, basically. And so regulators have a flexibility. They're not constrained in the way that judges are. And so I think that's really important. Coherence for regulators means that we want all the regulatory elements to be pushing in the desired direction. So at the moment, for example, just to talk about an example that I've been looking at recently about black box data, which is available in smart cars or connected cars. There's a whole ecosystem here where there are different stakeholders who have a different interest in accessing this information, including the motor car manufacturers and insurers, but also, of course, consumers and users of vehicles who are concerned that the data shouldn't be accessed and employed in ways which, are either contrary to their interest in privacy or data protection. So you've got a number of stakeholders with a number of interests, and you're trying to create a regulatory environment which will encourage, the beneficial development of new transport systems and possibly new products in the insurance market, which are tailored better for consumers, but without this being anti-competitive, without it being a problem in terms of data protection. It's quite a puzzle for regulators to put in. A bit like Rubik's Cube, the Rubik's Cube where you're trying to align all the colors on that cube. Yeah, so you kind of you're looking at competition law. You maybe think you've just got it in the right setting, and then you look around and you say, oh no, that's not going to work. There's a problem there for insurance or a problem for consumers. So I don't underrate the problems that regulators have in getting this all lined up in the right kind of way. But at least they I say they have more more flexibility in the way that they deal with it, and of course more resources to throw at the problem, and a better chance in the end than judges of judges and courts who are just applying historic principles. They've got a better chance of kind of getting the scheme of things into line with what the prevailing public view is of this, and getting some support for it. But then the other thing I heard in your remarks there really was if the technology, just how much power in the end do regulators have to retard or to stop technologies, and particularly particular features, and again, you suppose that we had a conversation now about the internet, and the online world, in which the question was, well, was it ever a good idea to be going? Would we be better off without it? People say, well, all sorts of marvelous things you can do, but really, it's a Pandora's box. This we opened a window on a world that maybe we'd rather we hadn't done this. But can you imagine, particularly where people are going to make money out of it, that regulators anywhere would be able to wind this back? Even if you're just looking within one national legal system, say in India or in the UK, where local regulators were trying to do this just for their own jurisdiction. I think the pushback against that would be enormous. It'd be like, recreational drug use, where people are addicted to it. You can't stop them in the end. It's certainly not where law depends on popular support. You just, there are things you can and can't do. And what makes it even more complex is that so many of these technologies, including the internet, but so many of them have a global reach. So, even if you could knock the internet back or regulate it locally, how you manage to then ring fence your own community against what's going on the internet more generally is a big question. So China or whatever you might be in Saudi Arabia, they can kind of build walls around the technology, but where people have a will to get online, then they probably find a way. And one of the things I hear a lot with in regulatory conversations is where you've got online suppliers of goods or services that you're trying to control, people kind of in the regulatory community just kind of accept that they're not going to be able to stop it. That there is an element in which technology is an unstoppable tide. That's true, and we can have these conversations about how regulators should respond to it. But it could be, I said this many years ago about biotech, that if people are interested enough in getting genetic manipulations or whatever it might be, trying to smarten up their children, or that the regulators won't be able to stop them, and that what we need to prepare for then is kind of a dig the ditch somewhere else, where accepting this is going to happen, we're going to try and find a regulatory framework which will enable us to live with it, because it is going to be a different world. So we need Law 2 style regulation, and Law 3 too. We need to have some humility about it. I don't think that regulators can are entirely masters of the empire.
Sure, I really appreciate the response, sir. I think the example that you gave regarding biotechnology, particularly the same, that of course regulators cannot control the same situation, because it's more about the way that entities come up with, and it's also about the issue of choice dynamics and how they are expanded. because I
Yeah.
think that has been the case for
Mm.
the market systems all across the globe. In
Yeah.
fact, I would say even with blockchain, the same is because there are two things regarding blockchain. First is the currency component, which is how currencies are democratizing, and second is the technological part, which is DLT, how it is
Yeah.
basically becoming popular and being used either in smart contracts or anything. So, considering the questions that we have sent you, and of course considering the nature of the discussion, I believe that we I have one question to ask, and this is a specific question with regards to legal education, and I
Yeah.
believe that is a very interesting question according to me. So my question is quite simple. Now we understand that these challenges develop, and the public law regulators just can't limit it. Private law has a very interesting role to play per se. So how should legal education, when it comes to administrative law and technology, be framed in a sense? Because I remember an article you published with IGLT in 2019 where you stated three stages of law and technology governance. First, you stated coherentist. We have been discussing coherentism for long. Then you stated regulatory instrumentalism, which is a second stage. And the
Mm.
last stage, which you stated what was which is technocratism, which is I would say technocracy, having
Mm.
things automated to such a way that you are just giving a sense of, I would say, reverse retribution. And fine, for example, I think I'm quoting your example only. If you are just going to drive your car, you have not fastened your seat belt, then the
Mm.
car would just not work even if you
Yeah.
use your driver's key or whatsoever. So you give the example that technocracy is not the solution because identically and practically speaking, that is something which is not going to work. It's just
Mm.
like saying that the social credit system in China, which has its own flaws and problems, we just can't implement it anywhere else.
Yeah.
So you said there should be a balance between the first two, which is coherentism, and the second one, which is, I believe, regulatory instrumentalism. Considering that, and for since a buffer has to be created for the first two kinds of systems, how should students of law involve in it? And from a perspective of education, uh, how should students of law and also students of technology policy engage with these issues? How they should learn about it as well as come up with their own design approaches to solve, because
Mm.
they these most of these don't have a lot of philosophical connotation people can make out of it. Much of it stems from the practical real issues, which will again come against the constructivist aspects of howsoever notions we create, because people of course create ethical principles, whether it is AI, whether it is anything, but realism hits back. It happens even in international relations, but again, I think in law it's also similar cases. So, these days. So what do you think of it?
Yeah. Well, thanks for all of that. Yeah. Well, uh, I well, first of all, I should say I have a new book coming out next year should be out in March, Rethinking Law, Regulation and Technology, in which there are two chapters about the law school, how we teach, what we teach, and how we research, what we research. And I think it's going to be well, and India is one of the leading players, I think, in having progressive thinking about, the law school now. But I haven't written so much about it. But funnily enough, in the September issue of the Modern Law Review, the my colleague, well, friend William Lucy, has written a review article based on Law 3.0 and the previous book, Law, Technology and Society, which his review article is called The Law School 2061. And yeah, this is responding to what I've been saying and trying to anticipate how legal education might go. And he has a particular view about this, but I think, and I have not too dissimilar a view, but I mean, in both cases, we think there's going to be a radical transformation of the law school between now and mid-century. I mean, first of all, the pandemic has forced us to rethink how we teach law. I mean, the online delivery. I mean, the fact that we're doing this, having this conversation online, is. I mean, I don't know whether if we weren't in pandemic conditions, I would have been in India talking about this. But there's so many of the discussions I have now are online when they would have been offline in the previous world. But we see, there are. I mean, while there might be pluses well, there are lots of pluses with this, but there are probably some minuses too. But the positives and negatives balance out in a way that I think in the law schools we're going to see so much of law being taught at undergraduate level and on the master's level. I think through online delivery, and that's going to become the order of the day. But what, although there's been already a rapid change in the way we're using the technologies to teach, and indeed, of course, the way students study. I mean, in the new book, I'm recalling that the two problems I had as an undergraduate law student were, first of all, that there weren't enough seats in the library, in the law library, and secondly, that some of the key things to read for tutorials, key material in the journals was just, there were too many students chasing after too few copies. Now, in the end, it was technology that did cut. This is really Law 3.0 thinking. New rules didn't make any difference at all. You could have as many rules as you like about decent behavior in the law library. It wasn't going to stop students doing all sorts of things to get access to those journals or the seats. But no, I mean, first of all, photocopiers relieved the situation quite, and you saw law libraries, instead of being places where people sat and read quietly, there were long queues at photocopying machines and people chatting and whatnot. But I mean, because students started copying material on an industrial scale. But of course, it's the real transformation is that all these materials now pretty much are available digitally. The digitalization of legal materials and portable devices so that you can access it 24/7. Yeah. I don't know, how many students in India still spend a lot of time sitting in a law library with the hard copy materials. But, I wonder if people do that. I think, okay, I mean, the worst things to do, but you don't have to be there doing that, really. You could be doing it somewhere else in your own time. Sorry. But the question of what we teach, or the curriculum, particularly the undergraduate curriculum, is one that we haven't yet generally addressed. And the curriculum stood still for a very, very long time. It is still a law 1.0 curriculum. That's, this is the point. It's a law 1.0. When you say, what are you trying to do here? We're trying to teach people to think like lawyers. And how do you do that? And what do you mean by that? It's all law 1.0, so I mean, even when students get away from the building block subjects of, contracts and torts and so on, to more like we say, specialized or optional subjects, where the character is heavily regulatory. If you're looking, say, at environmental law or competition law, company law, I mean, it's regulatory. But I mean, the way it's presented is just another body of law. I mean, a lot of it is legislation, but it's driven by completely different imperatives, and priorities are different. So I think that, for me, the starting point, the minimum is that students, when they join the law school, need to be given an introduction to what the landscape of law looks like in 2021. And that landscape is the Law 3.0 landscape, that these are the three conversations. These are the three sort of paradigms. They're coexisting. There are interesting interactions between them, which we can explore. But this is what's and of course part of that introduction is going to be that when you're thinking about the context for law, technology is, developing technologies are so much part of that context. It's not just that they're out there. Once you've got Law 3.0 in play, and you're automating regulation or automating enforcement, you've got technologies right in the heart of law. I'm an old-fashioned contract lawyer, and what we have been teaching, is a long time since I taught this, but so much of contract law was about the rules of offer and acceptance, and problems arising from the posting rule in English law. Which, what about emails to start with? What about emails? And then you mentioned smart contracts when you were just talking a few minutes ago. how do smart contracts fit into this universe of contract law that was the kind of the going set of rules back in the 19th century? We have too much of a back window view in Law 1.0, I think. And we need to say, look, this is where we are today, this is where we are, and it's changing very rapidly. And I think legal education, the curriculum has to change with it. Now, I know in a previous workshop with some colleagues in India, they were very interested in bringing the law school curriculum more into line with the needs of legal practitioners, particularly practitioners who would now identify themselves as sort of working in digital law practices, digital law, and this leads to a conversation then about whether law graduates need to be trained to do things like coding as well. To what extent can we isolate a legal education from more technological or technical disciplines? I don't know really what I do think about this, because I'm conscious that the technologies that have been in the spotlight at any particular time for those of us who've been interested in law and regulation and technology, those technologies do come and go. Artificial intelligence and machine learning and blockchain are having their moment now in the spotlight, that's for sure. And genetics and genetic biotech technologies, which were where this kind of started in modern times, more recent times, are not so much in the spotlight. But just like we've had, at least 2 winters, haven't we, with AI? Once there have been at least 2 periods when people thought AI was really going to move forward, and then it stalled. Now we're in another period where we've seen, probably because of the, the way in which computing power and processing has just come on so enormously, that we think AI is the answer to everything. But it could be that that we have breakthroughs in relation to interpreting the characteristics of the human genome in ways that make that all of a sudden a much more exciting area to be looking at, because that information suddenly becomes absolutely critical. And the focus goes there. Now, it's impossible for someone who's training as a lawyer to be a trained geneticist, to be a trained engineer, to be a trained data science. Okay, you can do law and computer science or whatever it might be, but I don't, unless you're kind of a Renaissance person, you can't do everything. And so I don't know whether it makes sense to say that all graduates have to have, a degree in law and computer science. So I don't know. But I do. But to go back, I do think that legal education, at minimum, has to start with an introduction to the landscape of Law 3.0, so the students know where they are when they and understand as well that when we're having discussions about how technologies might, for example, be used to enforce transactions, like in blockchain and smart contracts, or how AI might be used in the criminal justice system to identify high-risk persons, who really shouldn't be given bail or who shouldn't be released from prison or whatever it might be. We're not wandering off the mainstream agenda. Again, going back to the early days when I was lecturing in contracts, if I started talking about ethics, or business ethics and something like this, students would switch off. They because they got it in their heads that what they're there to do is to learn the cases, or to learn the law. And once you start seeming to open up a context beyond that, they kind of think that you're digressing. So you mustn't have students who think that Law 1.0 is still the kind of central gravity of all this. That's it's important and significant still, but it's not the center. In fact, it's hard to say where the center of it all is now. But I'd say it's in Law 2.0 if anywhere. But it looks as though it might be shifted to Law 3.0, and then Law 1.0 is definitely not at the center. I think the minimum job of for us in the law schools is to alert students to the whole landscape of law in the Law 3.0 way. And again, I mean, Law 3.0 isn't the end of this story. You know, it's going to evolve into a Law 4.0, and I suspect that that's going to be a conversation that is even more dominated by technical or technological considerations.
In fact, my last question was going to be, will we have weather law 4.0? So
Ah,
I really, yeah, so really
mm.
appreciate that you even covered that aspect. So if you wish to say something about law 4.0, of course, I would really appreciate, sir. So, of course, yeah.
Okay, so I think at the end of Law 3.0, I do offer a few speculative thoughts about where we might be going with Law 4.0, but it is purely speculative. I don't know. I think it depends a lot, as I say, on which streams or convergences of technology suddenly take a leap forward, you know, and propel themselves into the legal and regulatory domain as yet further tools that we could use. And yeah, one thought there is that all the tools we're talking about at the moment are really outside the human body. And it could be that, you know, that changing the regulatory environment. So when we talk about the regulatory environment, I mean, it's all around us. It's the space we find ourselves in. But if you were able to manipulate humans in their genetics or in some other way, you know, or you could implant devices which had a regulatory effect, that would be, you know, that would be a difference. I mean, in fact, I mean, I'm saying as though the inside or the external and internal distinction is important here. I'm not, you know, I'm not sure how important that is in the end, because for many people who use their devices to give them guidance on various things, you know, they might as well be part of their body, actually. You know, the line between our devices and ourselves gets blurry. And so, you know, I mean, the worry we have about, you know, that people like Julie Cohen and Shoshana Zuboff have highlighted about so-called surveillance capitalism, you know, and information capitalism, where we are so reliant on the devices which we freely accept into our homes, you know, which are digital assistants in one way and another, but where the data is being collected all the time um, by the providers, and that data can then be used, of course, in the first instance to try to put adverts in front of us, which we will respond to in a buying kind of way. But you know, Zuboff's thesis really is that that's just the first stage of a project which takes the tech companies to a point where it's not just that they can predict what we might be interested in buying, what we might, you know, in adverts that we might respond to positively, but they all can anticipate our choices, but they can actually, the tech companies can now control and channel our choices. They make our choices for us. And the more reliant we become on these devices, the less independent and autonomous I think we are. And although those devices are, strictly speaking, outside us, they might as well be within us, you know, because we brought them right in. But it might be that literally devices could be implanted, or it could be, again, you know, that if there are big advances in our understanding of genetics, of the interpretability of particular genetic features, that we start screening newborn children to see what sort of genetic profiles they have, and they're kind of marked from day one. You know, that you can almost say, well, this is the kind of life you're destined for, and you know, we're already putting them into some sort of regulatory track, or of course, I mean, it could be that the genetic profiling goes on earlier during pregnancy, and we're even more controlling about the kind of children that get born. That would be, I mean, this is all taking us, well, for people of my time anyway, into kind of dystopian futures. You know, this is not good. This is really, really troubling stuff. So don't misunderstand me. I'm not saying that Law 4.0 in any of these articulations is going to be good news. But again, going back to the questions that, you know, you were asking earlier on, I don't think there's any winding back of this. You know, I'm not. You know, I think it's reversible.
Indeed, sir. So, with this, we conclude the seventh episode of AI Now Season 2. I believe we had a really interesting discussion in this 1 hour, and those who being watch this episode might really learn a lot and might be really also interested to buy your book as well as read the book and share the ideas to others. And of course, once your book, which is to be published in future, comes in, I would be really happy to have a podcast with you, maybe. So
Okay.
I really,
Why not?
definitely, definitely.
Thanks
So
very much indeed. Yeah.
with definitely. So we end this live session. I just have a request. As we end the broadcast, I would just like to talk to you for 1 minute. So
Okay.
please just stay once the live broadcast ends. So tomorrow we will be coming up with an episode for Global Hint on the Afghanistan crisis with a very interesting panel. So those who are watching us, please do await us at 6 p.m. tomorrow again on Global Hint. And with AI Now, we will be coming up with a very interesting episode, maybe with entrepreneurs and experts again in the coming weeks. And lastly, I just have to say that as this episode ends in the coming 2 weeks, we will be coming up with the flagship event of ISAIL, which is the Indian Conference on Artificial Intelligence and Law 2021. So do stay put, do subscribe to Internationalism Global Podcast channel, and do wait as these updates come in. So till then, we end the session, and I thank Roger sir for attending this, and it's been a pleasure.